Very good. So now what about, okay, so quickly, wills versus trusts and estate planning. Is there a dollar number where suddenly it changed? If I'm worth $3 million, now I have to have an estate
Well,
versus
you
will,
mean a
or
will,
what's kind of the broad,
you mean a will
like,
versus a trust?
yeah, like what's kind of the broad,
Yeah, well,
like,
look, generally speaking, like I said, everybody needs a will, particularly if you have kids or you have assets. If you have assets in other jurisdictions, or if you're concerned about diminished capacity or other considerations, then we recommend a trust. In
right?
terms of asset level, I mean, it's really hard to tell. I mean, if you had $1 million in a bank account and you had a beneficiary on that account, then you might not need a trust.
Okay.
But you know, my strong preference for people, including myself, is I have two trusts. I have a life insurance trust, and I have a revocable grantor trust because I have property in different states, and there is a risk that I'll suffer from diminished capacity at some point because my father does and has. So I have a trust set up for myself, and the benefit of that is if someone suffers diminished capacity, their successor fares without any interference. And the problem with probate is generally it costs more, but that's really the small part of it. It's a lot easier to contest a will than it is to contest a trust.
Why is
So,
that?
well, because for the will, anytime you submit a will for probate, and this is in New York State specifically, you have to have a waiver and consent signed by the distributees. The distributees are that's the legal term for the people that would take under the laws of intestacy. So we have a lot of families, for example, where they have estranged children or they have another problem in the family where those people would not consent to the probate of the will. But if
Got
they
it.
had, but if the client has everything into a trust, the successor trustee can just continue to act as if they were the original trustee and grantor of the trust. And by the way, wills are public documents, whereas trusts are in a separate department at the surrogate's court where the public does not have access to them. So
Interesting.
yeah,
So
so
it's more private.
it's much more private. Yeah, I mean, of course, if it's the subject to litigation through discovery and so forth, the parties would have access to it, but not the general public, right? The general public can go down to the surrogate's court and pull up a copy of anybody's will they want to.